Good morning, everybody. It's your friend Rick. It is August the 25th, 2017. If you need to reach me, it's rick0327@me.com. All right, what you're looking at here is a notice of demand, objection, notice to dismiss. I could have put demand. It doesn't matter. Sometimes you'll see my paperwork. I'll leave this at. It doesn't matter. Okay, the little things like that does not matter. It's your point, it's your evidence, it's your facts, it's your case laws. That's what matters. Okay, so all this does here, this just makes it authentic. Okay, it shows the court that you're not that you're doing your own writing. Okay, and people like us, courts are intimidated by. That's the reason why they try and keep us out of the court. That's the reason why it's hard to get in a courtroom in front of a judge. My federal lawsuit, I never saw a judge. Waited around for 2.5 hours for an order to show cause. I did everything right, and they wouldn't let me see a judge because what they did was they sat and read my paperwork, and it was like no way they're gonna let me in front of a judge. The judge that vacated my support order, the one in the video. All right, nice guy, but there was no way he was letting me in front of him ever again. I never saw him again. I tried to get order to show cause with him a couple of times. No way. There was no way they would let me back in front of this guy. So the way to go is going by paper, and that's what we're doing here. All right, so I'm showing you this for a reason. All right. Okay, look, good news. My man Maurice submitted that document you just saw. He had a default order for child support. It's gone. Okay, ordered that the motion of Maurice is granted in the following respects. Effective nunc pro tunc, which is now for then. You know, they just can't say that. They got to use these Latin phrases. June 21st, the order of support entered on default is vacated. Okay? Hey, there we go. Isn't that nice? Isn't that nice? Okay. This is New York, by the way. New York is a bitch. Now, what I did here, I scribbled out her name, the support magistrate. Because they're watching my videos, I don't want to get her in trouble. It's nice. Thank you, support magistrate Jennifer. Thank you for following the law. Okay? So I don't want to get her in trouble because they're monitoring my videos. So, and any of the support magistrates, you're watching my videos, you know, follow the law. Because we're catching up to you guys, all right? What you're doing, you know it's wrong, and you're hurting a lot of people, okay? Yeah, there are a lot of deadbeats out there. I get it, but there are a lot of good people, a lot of good men and women out there that you guys are hurting. And that goes for all the non-judicial persons playing judges and, you know, being bullies, okay? I don't need a law degree to make a point in court, and neither does anybody else. Okay, my man John, he went to a hearing and he introduced my paperwork and he introduced the bill of particulars, and the lawyer was right away. You can't. There's you know what do you say? He had no jurisdiction, like because they're trying to use this bullshit that bill of particulars can only be used in criminal proceedings. Well. Being that you can be incarcerated for non-payment of child support or contempt, guess what, guys? Bill of particulars works. And the judge, the lawyer, right away did the old. What law school did you go to? That's their. They always fall back on that. And like, I don't got to go to law school. I know how to read the English language. I know how to comprehend. I know how to do research. A lot of these lawyers I found, what they do is they cut and paste paperwork from the previous lawyers. So like if a lawyer works in a law firm, like a lot of these stipulation of settlement agreements that they use in divorce, they're just cut and pasted from the previous ones. Because I've seen a lot of them. They're all worded the same. Okay, but let's get back to Maurice here. Maurice had a good day. All right, and it's vacated. So going back to June 14th, it's vacated. Nice. All right. Now, I'm going to explain to you why the Coram non-judicial worked. All right? Now, sport magistrates in family court, they claim they get their jurisdiction under Article 5 family court. Excuse me. Now, I want to show you something. They need your consent. Okay? They claim that but they need your consent. All right? And I should have highlighted this. I'm sorry I didn't. The individual submits to the jurisdiction of the state by consent, by entering a general appearance. That's why we got to start doing a special appearance. Or by filing a responsive document. See what they're doing? So in other words, by you responding, you're submitting to their jurisdiction. This is how tricky these people are. All right, I'm going to show you real fast. Where is it? Bernie, my man Bernie, he did a special appearance. He took right here. He got this dismissed the other day. All right. He took my notice of dismissal and he made it his own. He made his own order. He took points from my order of dismissal and he made a special appearance that he will not appear unless he receives proof of jurisdiction and evidence. And he went to court and he had a dismissal. All right, so that's a order vacated and a notice of dismissal in 1 week. Not a bad week. All right, so this shows you here that's how they get their jurisdiction. So we're going to fix that. And I guarantee you this. You have this in every state. This is just New York, but this is what they do. All right, I had a guy in California show me his paperwork, and they said that he gave them jurisdiction by showing up. But meanwhile, if you don't show up, what do they do to you? They enter a default judgment. So we're learning as we're going along. All right, that where is it? That this by Maurice is the culmination of doing things wrong, and when they come back at us, we're always learning. We're always changing our paperwork. We find a month and a half, 2 months ago, I find this Coram non-judicial, right? And that's what we do. So before a person had a judge, writ of error, right? So what'd she do? She went back and vacated it. So now, there we go. The child, number 8. There is any other basis consistent with the constitutions of this state and the United States for the exercise of personal jurisdiction. Now, how many times, like this happened yesterday, Brian and, what state was he? I think he was in Texas. And Brian had a judge tell him yesterday, or one of these fake judges, that statutes rule in this court. I don't care about the Constitution. This is what a judge said. A judge told him that. So what I told him to do, and I want all you guys to start doing this, you got to learn how to write. Listen, I'm here for you, but I can't do everything for you. You got to learn how to write. Look what happened to the dismissal you just saw. Bernie took my information, and Bernie's a bright guy. He's a computer guy. He offered to do a website for me. He's a bright guy. So he made his own orders. I have a lot of you out there that make your own orders. You take a lot of stuff you learn from me, and you write your own orders. Beautiful. Great. You don't have to use everything, all my paperwork to the letter. If you see something that you don't like and you want to tweak it, go, all right, have at it. That's how you learn. That's how I learned. So, all right. So what I told him to do is, right away, you send in a notice to the court. You can do this. So let's say this for argument's sake, notice of demand. You could write notice of trespass upon rights by Judge so-and-so. And you enter that. That way it's on the record. Now that judge was noticed that he or she is violating your rights and cannot claim that they weren't notified. That way, when you go to sue them, right, they can't pull this. Well, we have judicial immunity from the. See, what they claim is that they can't be sued under 42 USC 1983 because they have judicial immunity. No, it doesn't work that way. If you're acting under the jurisdiction of the United States Constitution, then you have judicial immunity. It doesn't mean that you have judicial immunity and you could violate somebody's rights. It doesn't work that way. But that's how they're getting away with it. So by us getting this stuff on record is showing a pattern that. So now let's say the next move is to do for Brian is to, before you appeal, you do the writ of mandamus, because what you're trying to do is you're trying to get evidence of jurisdiction before you do the appeal. So the writ of mandamus, by law, and based on the jurisprudence, everybody has a right to be shown jurisdiction when challenged, and you cannot move forward. That's why they do it. Well, this law, I have jurisdiction, like the bullies that they are, the judges. But you got to stand like, no, I want you to explain to me, like we talked about yesterday, explain to me, where is this jurisdiction? Where is the evidence? Like this document here, all right? We covered everything in this one, all right? Right? Here we go. Demand clarification of evidence introduced by the plaintiff petitioner with date of introduction into the court and the exhibit number or letter abbreviation. In other words, what was the evidence? What was it marked? What date was it entered? We know they don't do this. So how is she going to? So what she did, she vacated it. She didn't give her reasons why, but who cares? It's vacated. All right? Without evidence introduced by a plaintiff, a dismissal of this demand is void for being arbitrary and capricious. Okay? Let's close this up. All right? I want to show you guys. All right. That. Bear with me. Bear with me. Bear with me. Here we go. All right. Now, this is the powers of a support magistrate in New York State, and this is to prove that they're non-judicial persons. Support magistrates shall be empowered to hear, determine, and grant any relief within the powers of the court in any proceedings under this article, Article 4, Article 5, 5B, Sections 234 and 235 of this Act. Objections raised pursuant 5,241, that's the income withholding. Support magistrates shall not be empowered to hear, determine, and grant any relief with respects to issues specified in Section 455. That's money judgments. So if there's a money judgment support order entered against you, because the support magistrate is not empowered to issue one, they cannot grant relief. See, when a support magistrate issues, or any non-judicial person enters a support order, it has to be signed by a judicial officer. And then when it's signed by a judicial officer, it's the judicial officer's order, because it's judicial officer's signature that gives it jurisdiction and power. You understand? So, watch. Accompanied by findings of fact, all right, determination by a support magistrate that a person is in willful violation. See that word, willful? The courts have determined it's a very hard word to prove. All right, I'm going to be doing something with that word. I'm going to make a document asking the court, well, in the Bill of Particulars, we're going to ask the court to define what willful is. Okay? It's a very difficult word for the courts to prove. All right, and there are case laws out there to prove it. Violation of an order. What if there's no order? Under subdivision 3 of section 454 of this article. Anyway, accompanied by finding, but determination shall have no force and effect until confirmed by a judge. No force and effect. So what does that mean? Any order issued by a support magistrate without a signature of a judge, it's void. Has no legal force. So any child support agency, now, by the way, this is not just a support magistrate. This is any non-judicial person. All right? Now, you can't cite this law in your state. This is only for New York people. But I'm telling you, this goes in every state that has a non-judicial person. All right? And the Supreme Court in Burnham, right? Let's go find it. In Burnham versus Superior Court. All right? Here it is right here. Oh, this is Toomey. All right. Burnham, okay. The proposition that the judgment of a court lacking jurisdiction is void. All right? So any court lacking jurisdiction, any judgment issued is void, right? So traditionally proposition, the phrase coram non-judice, before a person, not a judge, meaning in effect that the proceeding in question was not a judicial proceeding because lawful judicial authority was not present. Now, we can also make an argument that, let's say here, that they did actually have a judge. The support magistrate followed all the procedures. She did a findings of fact, held a hearing, and then forwarded her papers to the judge, and then the judge signed off on them. But guess what? It's still void. Why? Because the judge wasn't present. It's hearsay. Okay? So that's another argument. But so let's get back to this. Before a person, judge, in effect, the proceeding in question was not judicial because it was not present and could therefore not yield a judgment. American courts invalidated or denied recognition to the judgments that violated this common law principle long before the 14th Amendment. So we don't need the 14th Amendment. A lot of people don't believe in the 14th Amendment. They consider it a war amendment that was issued by the Congress when they were still under the war provisions for the Civil War. Okay, that's another discussion for another day. All right, a lot of people out there, the hardcore people, believe you should never use the 14th Amendment because then you're claiming you're a citizen instead of being a human being, a man or a woman. But listen, if we can use it to our advantage, I say we use it. We announced that the judgment of a court lacking personal jurisdiction violated the due process clause of the 14th Amendment as well. So in other words, they said, we don't need the 14th Amendment, but it did. All right, so that's huge. So that's the reason why it was granted. Now, we have it 2 times here, but the determination shall have no force and effect until confirmed by a judge. All right, now I want to show you why I have you guys, here we go, why I have you guys going to the clerks, all right? Why it's a money judgment. Family court, so now, there's a support of family court enters an order requiring any party to provide for support of another party or child or both, providing for the support magistrate, whatever. Now, a certified copy of the order directing the entry of a money judgment shall be entered in the office of the clerk of the county in which the proceedings was commenced. Said clerk shall docket the same in the book, right? That's the book of liens and judgments, kept by him for docketing of judgments, as if said order was a transcript of the judge directed by the amount designated. So that's the reason why I have you guys doing this. Now, if it's not there, it's void. That's why I have you guys doing these things. All right? There's a method to my madness. This stuff is coming together. All right? You're just jumping on board now. You're jumping on board at a good time. All right? I got to shut this video down. But But I wanted to show you guys why the order was vacated from Maurice. And thankfully, the support magistrate, she followed the law. Hey, I don't know, but they know that these are coming from me. They know who I am. All right? Who knows? Maybe we might get lucky at some time that this is, now listen, this is really, 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 maybe I shouldn't even think like this. This is really wishful thinking, but maybe sometime in the future that anybody that enters paperwork coming from me might just be given, they might just grant them, knowing that, you know, my stuff is together. That can happen. There are plenty of times, that's the reason why when lawyers are established, they're allowed to ask for a lot of money because they've proven time and time again in the court that they're competent. And that's the reason why they can ask for a lot of money. So if a certain lawyer shows up, the judges give them latitudes. Or how about, I'll compare it to sports. You know, baseball player, basketball player. They're established, the referees or the umpires give them leeway because they have a reputation. So hopefully down the line, when they see this paperwork, maybe they know not to mess around. Because see here, there's no judicial immunity for anybody acting without jurisdiction. Okay? It doesn't matter. So maybe she saw that and she granted this. All right, so listen, it was a good day. If anybody needs my paperwork, it's rick0327@me.com. And the paperwork for the writ of mandamus, I told you guys, if you gave me a donation in the past, it's another donation. Okay, we went to a different court. All right, I did new work. All right, so I'm just saying that for a reason. I don't want anybody, you know. Some of you have gotten spoiled by me because I give away a lot of stuff for free. All right, but you guys see my paperwork, what I give you guys. You already got a really good deal for the, you know, for the $100 or $125 that I ask, $150, whatever, for the donation. You're getting a good deal. You can get a lot more. Like, you know, if I wanted to be a jerk, you know, I could ask for a lot more money. If I could say, oh, look, I got this guy, he got the default judgment vacated based on my paperwork. But I'm not. I'm not going to hurt anybody. I told you, I meet you halfway. I know a lot of you got money problems. Okay? All right, so listen, enjoy the rest of your weekend. I'll probably talk to you guys over the weekend. All right? And have a good Friday.